In this early corporations law case, Foss and a number of other investors were basically scammed, and the court decided it was unable to help. The purpose of the corporation was the purchase of land in the city of Manchester, which was to be redeveloped into housing and parkland and sold at a substantial profit. Back in those early days, individuals could not just form a corporation. They had to request an Act of Parliament to establish their corporation. While this particular group was waiting for the passage of their Act of Parliament, some directors started buying up parts of the land which was to be developed, but in their individual names. From a modern perspective, this was insider trading and conflict of interest. Essentially, they bought the land for a cheap price, then sold it to their own corporation at a massive markup, keeping for themselves profit which the corporation should have made. Once the corporation was formed, those same directors then mortgaged properties to raise additional money, all without the appropriate authority. Foss sued on behalf of all the swindled shareholders, seeking the court's protection. The court found that if the directors had done anything wrong, then it was the company that they had wronged. The company would have paid too much for the land. The company would have been liable for the improper mortgages. So neither Foss nor any other individual shareholder could bring an action against the directors. The Vice-Chancellor, Sir James Wigram, said, "In law, the corporation and the aggregate members of the corporation are not the same thing for purposes like this, and the only question can be whether the facts alleged in this case justify a departure from the rule which, prima facie, would require that the corporation should sue in its own name and in its corporate character." He found that in this situation a departure was not justified. This case established two rules. First, that individual shareholders could not sue on behalf of a company. The company itself must be the plaintiff. And second, that the courts would not interfere in any transaction which could potentially be ratified by a company meeting, such as the decision to purchase the expensive land. It is clear that this decision worked an injustice, and the rule in Foss and Harbottle is now mostly known for its exceptions, which were developed in a series of later cases.